assuming Jason probably started on the seller packet with the same thing, but either way, I still feel like it's worth pointing out and talking about. And that is, right up here at the top, it says, this is a legally binding agreement. Read carefully before signing. So I always want to make sure to point out to you guys that when your clients sign this, when we sign this, this is a legally binding agreement. Now, the thing that's interesting, I guess, to me at least on this is the listing side of it. We tend, and when I say we, I'm more than just meaning real estate in general. Brokerages tend to enforce the listing agreement more often than we enforce the buyer broker agreement. But it doesn't change the fact that it is a legally binding agreement. And in fact, I got off the phone today with a broker down in southern Utah, or maybe central Utah, I guess even central to southern Utah, that one of our agents had signed a buyer broker with. It's kind of convoluted story, but more interesting than what we're talking about. So I'll share it with you. So the agent had been talking to this person on the phone for a while. On August 9th, met with them, asked them to sign a buyer broker, and they were a little hesitant at that point. So he said, that's fine, we can wait. In the meantime, then she finds this property down, which she found the property actually from our agent, is how she found out about the property. But she ended up calling the listing agent on the property, talking to him about the property and saying, I'm very interested in it. So he sends over a buyer broker and a Repsy and all that. Well, in the meantime, before he sent the offer though, our agent then got a buyer broker signed with this lady. And so here's the point of my story is yesterday, this agent in central southern Utah is saying, I'm entitled to the commission if she buys this house because I talked to her on the phone. I explained everything to her and okay, he can have that opinion. But he also then, our agent told him, well, I've got a signed buyer broker. And he said, well, send it to me. So he sent over the buyer broker and this guy says, well, yeah, that happened though after I had already talked to her on the phone. So he told the buyer to tell our agent to cancel this agreement. And so here's the whole point of that long story of me sharing this with you. This is a legally binding agreement. How many parties have to sign this contract for it to be in effect?
2, right?
You're right. So the buyers would sign it, and then us as a brokerage, so you as the agent can sign it on behalf of the brokerage, is you're going to sign it, they're going to sign it. So if it takes 2 parties to sign to get in, what does it take to get out? 2 parties. So he's saying to us, well, tell them to just cancel it. Well, if we don't want to cancel it, then it's a legally binding agreement. Okay. So just keep in mind though, that not always do we, and again, when I'm saying we, I'm meaning brokerages, not just our brokerage, but all real estate brokerages. It's more common for somebody to maybe have signed this and then we don't enforce it, even though it is a legally binding agreement. And what I mean by enforce it is, well, I'll come back to that. When we get into section 2, I'll come back to what we're talking about and we'll talk more about it. But I just always want to point out, this is a legally binding agreement.
So Ross, I'm kind of lost. The one that wanted the cancellation, basically, he was trying to help the same client, but he didn't get a buyer broker.
Yeah, he had not gotten a, so he was what he's saying is he has agency by implication. And
but this needs more than implication, right?
Well, that's what I was going to say. What did you guys learn in real estate school about implied agency? I'm just curious of what they're saying about it in school.
It's implied, so you do want to get it signed. So, I mean, honestly, they aren't held anything to you.
Yeah, because here's where I come from on this. Is implied agency a thing? Yes. But I think it's gonna be pretty hard to prove because when you learn in real estate school, what did you learn that the statute of frauds was? And if you're not sure, you can be like, oh, we're gonna let Zoom answer that question.
I
So,
forgot about
someone
that.
on Zoom. What's the statute of frauds? Anybody remember? All right, well, I will save that then on Thursday when we play a really fun game that you guys are all gonna be here in person for, right? Except for Jordan, he'll be in St. George. Okay. Statute of frauds is it has to be in writing. So the elements of a contract, there's 4 elements to a contract. And then the 5th piece of it is that it has to be in writing. So he can say we have implied agency, but okay, you still need to get it signed, okay? All right.
So in other words, yes, he might have implied agency, but when you compare the implied to the contract is going to be the one, wouldn't it?
Right, yes, yep, you got it. All right, next, so the next thing we're gonna go through, so. And here's kind of my plan on this, guys, is I'm gonna approach this. The way I basically just explain it to somebody, because when I sit down with a client, I always tell them they have 3 options. So when we're gonna go through, whether it's the listing agreement, the buyer broker, whatever, I tell them they got 3 options. They can read through the whole thing if they want to. And technically, I guess they have a 4th option that I wasn't thinking that I was necessarily gonna bring up, but because this is a legally binding agreement, if they want an attorney to review it, they could do that too. So there's really 4 options, I guess. They can have an attorney review it, they can read through it. The other option is I can just explain to them what it says, or the 4th option is they could just sign it
Yeah, without explanation.
without anything. And what do you think most people choose?
He explained.
Yeah, most of the time people will say, well, just explain to me what it says. So that's basically what I'm gonna do with you guys, but I also do want to say this. You should read this entire contract at least once. So if you never have read it, you should sit down with a yellow highlighter or with a pen or a pencil or something, and you should read this entire contract, highlighting or writing down any questions that you have about it or that maybe you don't understand, and I'm happy to sit down and go through it and talk to you about it. But you should actually at least read through it at least one time in your career as a real estate agent. Okay, all right. So I'm just gonna kind of go through it that way as if I were explaining it to somebody. But so this first section here is the exclusive buyer broker agreement, and it's saying it's entered into and effective the blank day of month and year between Century 21 Everest and the buyer. So what should you put in there? Where, in terms of the buyer's name, like what name should we put in there for the buyer? And I don't know if I'm asking that right, but how do you know what to put in there?
The same name that's on the loan.
Okay, good, love it. That's exactly the best answer. So you want to put, so you said tax records. The problem is if this is a buyer, they might not have any tax records. But on a seller, that's a good place to start. But on the buyer, then yeah, I always want to start with, have they applied for the loan and what is the name? Who's going to be on the loan and how did they apply for the loan? And I like the name on here to match that. If they haven't applied for the loan, then I would want to just find, hey, well, when you do, what's the name you would put in there applying for the loan, okay? So we want that to match. All right, next, terms of the agreement. So, and we're not going to read through the whole thing, like I said, but there are pieces that I will read to you. So the terms of the agreement is just saying the buyer retains the company, including, and then you're going to put in your name as the buyer's agent, as the authorized agent for the company. Oh, I didn't hand you guys. I have for you guys that are in person here, if you want to take notes on an actual papers, I can do that. If you don't care, then that's fine
Yeah,
too.
I do care.
Okay.
Do you want one?
He has one.
Oh, you got one.
He got one. All right, so you're gonna put in your name there, that you're the authorized agent for the company, and that it's ending at 5 PM on blank day, month of year. So what should we put in there? How long of a time frame should we put?
At least 6 months.
Okay,
But isn't that something we determine with the client?
okay, so I've got in a 6 months and determine with the client. Any other thoughts?
I usually do a year.
Usually do a year, okay? Anyone else? All right, there's not a right answer, is what I will tell you. So I'll tell you how I do it. That doesn't mean it's right, doesn't mean you should do it that way. But I will just share with you the way that I go about it. And so here's how I like to do it. The way I like to approach it is from the standpoint of I like asking the client, like, what's your time frame in which you want to be into a property? And then based on what they tell me, so let's just say that they said, I don't know, in the next 2 or 3 months, we want to be into a property. Then I'm probably going to do it for like 4 months. If they said, oh, I don't know, sometime over the next year, then I might ask a few more questions before I sign it. Now, why? Because let me be clear, there is nothing wrong with doing it a year. There's nothing wrong with 6 months. However you want to do it is totally your call. I just always want to make sure that we remember when we sign this and we become their agent, what do we then owe to the client? What do we call those things that we owe to them? Starts with an F. The fiduciary duties. That's right. We owe them fiduciary duties. And those fiduciary duties are in place. So if they want to go see properties, what do you have to do?
Go see them.
Yeah, you got to go show them. We owe them all these fiduciary duties. And so I always just say, kind of keep that in mind as you're signing these buyer brokers. Now, I know that there are a lot of agents that do it for a year. And part of what the thinking is I want to make sure that they are committed to me over the next year. And that, again, that's fine. I'm not saying don't do it. Just recognize you owe them fiduciary duties, that if you then don't give them those duties, it could be a situation where they could say either they're estranged from the contract or that you have abandoned them. And even if you have a buyer broker with somebody and you don't stay in touch with them regularly, and they go buy a house with somebody else, and you were to go back and say, hey, you bought a house, but I have a buyer broker, and it was a scenario of, well, yeah, but we haven't talked for months. You're probably not going to get paid on it. Now,
How about if they are the ones not returning the contact? Let's say that I text them that they've been receiving properties from the MLS, but they just play dead.
yeah, so if they just play dead, then as long as you could show you were still doing your part, then we would have a leg to stand on. But because that would be the scenario of more of they are the ones interrupting or creating a problem. But if you're the one not doing, if you're not calling them, you're not doing stuff like that, and they went and did something, you would have a hard time enforcing this, because the first thing that a judge would be looking at is, did you do your fiduciary duty? Did you give them reasonable care and diligence? Is where I think of the fiduciary duty that they would say, well, you didn't even stay in touch with them. So what would you expect them to do? So anyway, so my thinking is just for me personally, I don't want to get stuck in a scenario where I'm having to show people properties for for me, again, this is just personal. I'm not saying that you have to do this, and I'm not saying that it's wrong. For me personally, with where I'm at in my real estate career, I don't want to be connected to somebody through a buyer broker unless I feel like they're serious about buying and they're going to go out and do something. And now, so the flip side of that, though, is there is an advantage to having somebody sign something for a year, because now they feel bound to you. So you just have to decide where you're going to do that. I just, as the principal broker, would say, whatever time frame you do it for, keep in mind your fiduciary duties that you owe to those people and make sure that you are honoring those for that length of time. Okay? All right.
So for the ones playing dead, it's important to keep track of what I'm doing in that
Yeah.
time period,
Yeah.
even if they are,
Yep.
like I said, playing dead.
Yeah. If they're playing dead, you would want to just have something to show. What, and it could be just your phone, text messages. It could be your call log showing, like, here's how often I called.
Okay.
So, all right. So again, on this, let me just make sure to be really clear. On the listing side, it is more normal that we do say a 6-month listing. But on the buyer side, just keep in mind, it's whatever you want a time frame you want to put in there. And especially on the listing side, and maybe even the buyer side as well, part of what's going to play into that for me is going to be determined by, like, during COVID, when properties were flying off the shelf, you probably could have done a listing for 1 month. And if it wasn't sold in the month, it probably wasn't going to sell. I mean, unless they would be willing to do price reductions and things. So that based on the market, there's going to be some ebb and flow to what I would say the time frame should be. All right. Next then, and it goes on to say that will be their exclusive buyer agent, locating and negotiating for the acquisition of property in a blank county or counties. So if you're just wanting to do it for any of Utah counties, you could just write in there any counties. Or located at, and then it's got a spot for the property address. So here's the thing I would recommend is just don't go show properties to people without a buyer broker signed. And again, there are going to be times when people are going to, I totally get that. But just know that this gives you some protections, and at a minimum, like, you're going to have people that say, I don't want to sign it. Like, I signed one once and then I was stuck to this agent for a year and I didn't like them or whatever. So they're going to have some people that are hesitant to sign it. So, but for me, at a minimum, there's no reason, well, if there's a reason that they're not going to sign it based on even just the property address, meaning if you're going to go show them 2 or 3 properties, to me, there's no reason they couldn't sign it based on those 2 or 3 properties. That at least, because at least if I go show you these properties, you're planning on using me to buy the homes. If they won't sign it for that, is when you really want to start to question, well, what's the reason why? Is it because they're going to use you to go look at the property, but then have somebody else write the offer? In which case, I don't want to go show the property if they're not going to. So anyway, that's how all that works. So you have 2 options. So you're either putting A or B
So,
in here.
quick
Yes.
question, Ross. So do we have some liability if we walk into a property with somebody that we don't have a buyer broker?
I don't know that your liability would be different whether you had a buyer broker or you didn't. That's a good question. I don't know that it would be any different. I think you'd have the same liability either way.
Because I just was thinking. Basically, I will be bringing a stranger, which they are strangers, but with no legal connection at all. We're just walking in.
Yeah.
Both of us.
Yeah, no, the only thing I would say, I guess, potentially would be down here under the attorney's fees. Is once they've signed this, they're agreeing that in the event you did end up in court for some reason, that the prevailing party is entitled to reasonable attorney's fees, and without that, you're probably not gonna have the option to go after attorney's fees. So I guess when you say, is there an advantage? Yeah, if for some reason you ended up they ended up suing us, then you have that protection, or at least if we win, we don't have to pay the attorney's fees. Without it, we still might have to pay our attorney's fees.
Yikes. Which can be significant, right?
Could be, yeah. Okay, next, the buyer broker. So on this piece, again, the way that I typically explain it to people is that I'm saying this brokerage fee section is saying that when you go out and look at properties. Now, in fact, let me back up for a second. based on when I first got my license versus how things are in the market today, I would treat this section differently today than I did before. Meaning, when I first got my license, you could have put in here 0 as the amount for the brokerage fee to be 0. And you would have probably been fine because essentially everyone offered 3% on the MLS. In today's market, and thankfully I haven't seen this very much recently, but I saw one listing within the last few years that they were offering on the BAC $1. So if you were the buyer's agent, you would get paid $1 for that property. So because of that type of stuff, and or you're seeing 1% and those type of things a lot.
2.5.
Yeah, 2.5. I would recommend making sure that when you get to this section with your buyer, that you're having discussions with them about what it means. And so here's how I would go about doing it, is I would be getting to this section and saying to the buyers, that what this is saying is the way that we're going to get paid our commission is from the MLS. So if you look down under, find where exactly it's at. Right here. Oops. So this section right here says, if the property acquired by the buyer is listed with a brokerage, the buyer agent commission paid to the company by the listing brokerage shall satisfy the buyer's obligation for the brokerage fee shown above, provided that the BAC is not less than the amount shown above. So basically what we want to do is have a conversation, and this is where you as an agent are going to have to decide how you want to handle this, because if you put in, let's say up here, I put 3% plus $295, which is what you want to, on this line, you want to put in a minimum of that. Some agents do $495, some do $595, some do $695. But minimum is, our standard for the company is $295. So let's say you put 3% plus $295 here. What this is saying is, if the property that the buyer buys has a BAC equal to or greater than whatever amount is put in here, the buyer won't have to pay us anything. Well, the $295 they would have to. Which I hear agents say all the time, you know, it doesn't cost anything to use me as your agent. And that's not totally true, because again, if you came across where the BAC said $1, are you going to be okay with that?
I mean, they will.
Yeah, the buyer will be, but I'm asking you as the agent, are you going to be okay with it?
No.
So I am seeing where agents will put in 0 right here, 0% plus maybe $295 or whatever. I'm seeing that. Or I've seen where agents write MLS in right here, implying that what you're going to pay us is whatever's on the MLS. And again, this doesn't happen very often, but what if they happen to find a property where it says $1? You've now just told your buyer, I'll represent you for $1. And I don't know about you, but I'm not willing.
Not the truth.
What?
Which is not the truth. I'll do all of this for $1.
Yeah, well, that's just it. So you have to decide kind of what your minimum you're willing to accept would be. And so here's my recommendation is, I would say the conversation you want to have with them is, it's our company charges 3% plus, and then whatever you want to put in there, $295, $495, whatever.
So if you see it where it is $0 or $1, will you like reach out to that agent and talk to them about it?
Well, so that, yeah, so what I want to do first though, is I need to have this conversation with my buyer first. So yes, I'm probably going to do that. So what I want to do is I want to explain to the buyer, I need to be paid 3% of the purchase price. We are going to come across properties that are offering less than that. So if we do come across a property that is offering less than the 3%, I need you as the buyer to tell me as the agent how you want me to handle it. And then I would say to them, here's what our options are. If we come across one that's less than 3, the first thing is, with your permission, is I will call the other agent and see if I can get them to increase it to 3%. And I would say you always want to do that. Like for me, don't ever just accept, oh, they're only offering 2.5. At least try to get 3. Why not? And so that's where I would say to the client, and for me though, I'm probably not going to make the buyer pay me 3 if they were only offering 2.5. But if I have it as 3, and this is what I would be telling the client, if I have it as 3, there's a better chance I can get the other broker to pay me the 3%. And so I would then call up the other agent and say, hey, I've got some people, they're interested in your house. Notice you're only offering, let's say it's 2%. They're only offering 2%. I've got a buyer broker though that says they have to pay me 3. And so and get permission from your client to do this. Okay. So if I can't get you as the other broker or agent to be willing to pay us 3%, my client's probably going to have to go look at a different house because they don't have that extra 1% to pay of my brokerage fee. So just try at least to negotiate getting that fee to be up. And sometimes I'll even use it as to say to the other agent, hey, you don't have to tell me what you listed the home as, but if you listed it for 5 and you're offering 2.5, use this as a way to go back to your seller and get yourself a raise too. So let's get both of us a raise. Go back and tell your client, hey, it needs to be 6% so we can offer 3 to whoever. And then if they do that, fine. If they don't, that's fine. But the other thing is they may be, here's how I always approach this. And especially in today's market, this is true. Always approach every transaction as if the other agent needs the money worse than you do. Treat it as if they are probably more in need of commission than I am. And I don't mean that from the nice standpoint of like, well, so let them have more. I don't mean that. But I'm just saying, like, I have found throughout my career, most of the time an agent wants to get a deal and something is better than nothing to them. And I approach it as something is not better than nothing necessarily to me. I want to get paid what I'm worth. And I'm, again, back to, I'm not going to go do this for $1. So for me, I want to get paid the 3%. So I'm going to do everything I can. But again, you got to get your client's permission to, hey, with your permission, I will go and talk to them and see if I can negotiate that up. In the event I can't, if for whatever reason they won't adjust it, then I would tell the client, you and I will come back and have a conversation about how to make this work. Because what I don't want to do is get in the way of you getting the property you want, but I also do need to make sure I'm getting paid.
So Ross, the way things are right now, I had another agent in another brokerage we were, that he said that he found out that the listing agent put 2.5 because the listing agent was taking 3.5.
Yeah, I was going to say, I know for sure that happens. I know top agents in our company during COVID were doing that. They would go take a 6% listing and they would offer 2 to whoever brought in the buyer. So they were keeping 4.
So, but
there's nothing wrong with, I mean, let me rephrase that. That's okay to do. I personally feel like there's something wrong with it, but
I personally do too.
but there, you can do it. Nobody's going to get in trouble or anything for doing that. So, but that's again back to where I come from of saying, like, I believe most of the time if an agent did that, listed it for 6, kept 4, offered 2, if I called them up and said, I got somebody who's interested, but they're not going to do it unless I can get 3, that agent's more likely than not going to give you the other 1%. I sign a ton of escrow instructions where we're now getting 3 because agents are calling and talking to the other agent to get them to increase that. So I just want to highly recommend to you, when you're representing a buyer and it's less than 3, try it. What do you have to lose? Like, the worst that's going to happen is the agent's going to say no, and then you can make a decision.
4 and I want to give you 2.
Yeah, so just at least try, I would say. All right. Okay. So, if the BAC is less than, so that's the next piece on here. If the BAC is less than the amount shown, buyer will pay the difference at closing. So just have a discussion with your buyer, explaining to them and getting permission from them. If somebody's offering less, if you'll give me permission to call and negotiate and even play poker, that's what how I always tell the client is give me permission to play poker. Give me permission to call them and say, my client will not buy this house. And I just make sure the client knows, like, I'm not gonna get in the way of you buying the house. If this is the house you want, we'll figure out how to make it work. Now, the exception to that though is, again, if it's $1 and we can't get the seller to be willing to pay more than that, then I do want my client to know, and I'll tell them, we'll have a discussion if we come across that before we ever look at the house. Because you as the buyer need to know, if we go get this house and they're offering $1, you're gonna have to pay the 3% or an amount that we determine is fair. Does that make sense? Like I say, thankfully that's not happening too much anymore. But because of where the market's at, it's people are being willing to offer more, but you still are seeing a lot of 2 and 2.5. And so use this as a way to go to them and say, my client signed a 3 and they don't want to have to pay me, so they'll go buy a different house. But get permission from your client to play poker with them that way.
To negotiate.
Yep, to negotiate. That's probably a better way to say
Yeah,
it than play
negotiate.
poker, negotiate.
Because poker sounds not very good.
Yeah. Okay. Next section is the protection period. Protection period is just saying if within blank months. So what should we put there? 6? Any other thoughts?
I have 6 too,
Okay, 2 6s,
but I have 3 too.
3, okay.
We just do 1.
1, okay. Yeah, so here's the thing. I would at minimum do 1. That's what I would tell you. We had an agent last year that put 0 on there, put in if within 0 months after. And the buyer, after the contract expired, went and bought a house with somebody else. And the house that our agent had shown him, and our agent came and was like, I feel like I'm entitled to commission. I showed him the house. And I said, well, let's take a look at your buyer broker. Pulled it up and it said 0. And I was like, you gave yourself no protection. So too bad. I mean, unfortunately, that's kind of how it played out. What?
Is it really common for that to happen?
To put 0?
No, just
Oh.
for people.
No, it's not common for that to happen. Yeah, but it is that's the way I always look at it. Is I always, when I get to this section, explain it to the clients as this section is going to keep honest people honest. That's the point of the protection period. Because here's the other side of it. Once this expires, if the client won't continue, extend it, whatever, I'm personally probably not going to put the effort and energy into trying to figure out, did they go buy another house? Like, I'm just not. Now, is it possible that, they move into your neighborhood, move next door to you? Then yes, okay. Now I might be like, hey, you'd signed the protection period. You went and bought a house or whatever. But for the most part, I'm not going to spend the time chasing around to see, did they ever buy a house? Now, like I said, there are scenarios that it makes sense to do that, but it's pretty rare. So,
Russ, I
yeah.
have a question on that.
Yes.
So let's say let's say you do 6 months on the date above, not the protection period, and that ends, and then they go sign a buyer broker and buy a house that you've shown and you have it within your protection period. Do they technically owe both of those agents commission?
So the technical answer is yes, they would, if it was a property you had shown them. So that's the thing you got to make sure you remember is
Right.
protection period is for that.
Like it wouldn't make their new buyer broker invalid if it was a property you had shown.
So it probably, well, here's the thing. So here's the challenge with that. And I've struggled with how to handle this on our end or not, but if you go look at the way that the board, I'm not positive on the buyer broker, I'll have to look at it, but if you go onto the MLS and you were to pull up a listing agreement, The protection period says, the last piece of it says unless they've signed with somebody else. Ours doesn't say that. And I'm okay with ours not saying that because it potentially may have somebody feel more bound to you. But to answer your question, we are gonna have a really hard time collecting that other commission if they've gone and signed with somebody else after ours is expired during the protection period. Because we also, part of our code of ethics is that we aren't gonna bind somebody to pay double commissions. And all of a sudden now you're forcing them into this double commission scenario, so.
Well, they kind of did it themselves.
Yeah, it's true. So it would be sticky, I guess, is the best way to answer it.
Okay.
So,
Well, are in all those situations kind of sticky?
what's that?
Are in all those?
Yeah,
situations
my
kind of-
whole job is sticky, yes, exactly. Yeah, so I would say we always just take it on a case by case, Jordan, is kind of how I approach it is. But I would say there's gonna have to be a pretty good reason. If this is expired, it's during the protection period and somebody went and signed with somebody else and then bought. We would look at the scenario and if it makes sense, yeah, we're gonna go after it, but I haven't seen that happen much at all. So maybe I should even say if ever, but. Other than, like I say, the one scenario where it maybe could have been last year, but the agent had put 0 there, so I was like, you gave yourself no protection, so. All right, next, buyer's representations and disclosures. So when I get to this section, which by the way, the rest of this will go pretty quick. And relative compared to what we've been doing, but. Buyer's representations and disclosures. The buyer warrants that the buyer has not, and this piece I do want to point out a few things. The buyer warrants that the buyer has not entered into any other exclusive buyer broker agreement with any other brokerage that is still in force and effect. And the buyer will, A, in all communications with other real estate agents, notify the agents in advance that the buyer has entered into an exclusive buyer broker agreement. So I always make sure to point this piece out to my clients when we're going through this. Is part of what they're agreeing to is anytime they talk to an agent that they will tell them they've signed this with me. Because that really is their responsibility based on this is for them. Anytime they talk to another agent that they let them know I've signed a buyer broker. And I always present it to the buyers as it'll keep agents from bugging you. As soon as you say I've signed a buyer broker, they should leave you alone. So, all right. The other things that this section goes through and talks about is that they'll furnish us with any relevant personal financial information. They'll exercise care and diligence when evaluating the condition of a property and that they will hold us harmless. Which, so I guess back to what you were talking about, Luz. The advantage to having them sign this, it would be this 4D that says they will hold harmless the company against the buyers and the buyer's agent against any claim as a result of any injuries occurred while inspecting the property. So I guess if you didn't have this sign and somebody got hurt, they could sue you versus if you have this, you're saying they'll hold us harmless if they do get hurt. So to
Yeah,
your
'cause-
question.
Yeah, because anyway, yeah, all right.
And then they're also agreeing that upon signing this, they'll also review and sign the buyer's due diligence and wire fraud alert disclosure. And that they will disclose to us all properties that they are negotiating to acquire or have an interest in acquiring. The idea behind that is if somebody tells you, oh yeah, we've got an offer out on a property, there's probably a pretty good chance that they've signed a buyer broker with somebody else too. So that's the idea of in this, of you just asking them, hey, do you have any other properties that you've been interested in or you've talked to anybody about, made offers on before signing this? And if they say yes, then you want to dig a little deeper. Yep. All right, so it only took us 42 minutes to go through page 1.
42 minutes, really?
That's why I said we'll go faster from here on. So, all right, next, section 5 is agency. So when I get to this section, this is where I just explained to the buyers that my job is to represent them, look out for their best interests. I always tell them we're on the same team. Like when it comes to negotiating, I always tell them we're on the same side of the table. We're not negotiating against each other. We're on the same team. Anything I know, you're gonna know. I'm gonna tell you everything that you need to know. I'm gonna help you. You don't need to keep any secrets from me, like we're on the same team, okay? So I always explain that. Then I get down here to 5.2, which is the duties of a limited agent, and I say the only exception to that would be if for some reason you ended up being interested in a home that I have listed for sale, in which case some of those things I would become limited in. And then I always give them the example of, for example, if we go look at a home that I have listed, don't tell me the highest price you would be willing to pay, because well, I mean, it doesn't matter if they tell you, because you can't tell the other agent. So, but I tell them, so if I know the lowest the seller would be willing to accept, and I show you the property and you say, well, would they be willing to go to this price? Even if I know, I can't tell you. I just have to stay neutral. But I always explain that to the buyers, that that's going to be no different though of if it's listed with somebody else, because they're not going to probably tell me the lowest the seller would go either. So I just kind of say, it's really not a whole lot of difference. It's just, I may know something I can't tell you if I'm in a limited agency scenario. Are you okay with that? They say, yeah, that's fine. Great. Then we go to the next. All right, next section is professional advice.
Wait, before you
Yeah.
move on,
Go ahead.
when there is two agents from the same company, then the company needs, there is something to disclose, right, or a form or
Yeah, we've got
something?
a separate limited agency form that you would have to use
Yeah.
if both agents are with the same brokerage. Correct. All right, professional advice. When I get to this section is where I just tell them, I'm trained in the marketing of real estate. And this is really how I do it when I'm working with a buyer. When I get to this section, I say, what this section says is don't trust anything I tell you. And they usually look up at me like, what? And then is when I will explain to them of basically what it says is I'm trained in the marketing of real estate. I'm not a CPA. I'm not an attorney. I'm not a home inspector. I don't know all the zoning codes. I'm not a surveyor. And I just, at this point, I will pull out the buyer due diligence form and say, all of these things on the buyer due diligence form are telling you there are professionals in that area and it's not me. The reason I always say don't trust anything I tell you is because then when I go out and show them properties, and we get there and they say, hey, so where's the property line for this? I always can then go, remember that when we signed the buyer broker and I told you don't trust anything I tell you? And they'll usually go, oh yeah, that's true. I guess you don't really know. Now, I will say to them, it looks to me like this is where it is. But if that's a concern to you, don't rely solely on me. You should get a survey done. So I just always tell them, and because that kind of stuff will come up all the time. They'll ask you questions about electrical, plumbing, stuff like that. What do you think about this or that? And I always just go back to, remember that document that I had you sign that says, don't trust me with that kind of stuff. I can tell you what I think, but don't rely on it because I'm not a professional in that area. Okay, so that's this professional advice section.
So in that case, is it even advisable to say anything, Ross? Because they can always quote, oh, well, you told me.
Yep.
So.
Yeah, no, it probably is better to say, I don't know. Here's the hard part with that I've found is the client also does need some guidance, but like for me, like back to a property line. I will typically walk to the curb to where the pin would be, and I say, typically this pin is gonna be where the property line is. But again, like don't rely on because I don't know that somebody didn't move it, that it was wrong put in. Like my first house that I built, when I went to put the fence up, I went and put a line where I was gonna put the fence. And my neighbor came out and was like, hey, that line is off by 6 inches. You've got 6 inches of my property. And I don't believe that I did, but I just said, okay. Like, I was kind of like, all right, sounds good to me. That's 6 inches less of grass I gotta mow, so that's fine. I don't care. So I moved the line and was like, are you good with it right there? And he said, yes. So. Is it possible that he was encroaching in my property? Probably, but. I was just kind of like, whatever. So my point being just, to me, I'm gonna say to them, look. Just because there's a fence there doesn't mean that is the property line. If that's something you're worried about, you need to check it out deeper.
Yeah, 'cause
But I still am gonna usually say, I'll usually walk out and say to somebody, these pins. Typically show where the property line is.
what pins are you talking about when you say?
Oh, so if you go out and when you go home on your curb. Where your curb is, if you go to like where your property line is, there should be a little, like kind of a nail pounded into the cement. There, I always call it a pin, I don't know if that's really what it's called, but. There should be a little like nail thing in there that should show this is where the property line is.
And I suppose all the houses should have that name.
Yes,
Come on, check it, I never seen them.
yeah, well, now,
I never
now there's your homework for
Yeah,
tonight, Liz.
I need to
Go
check it.
see it, check both sides of your house and see,
I want to see those pins.
All right, so again, just that's where I'll tell them, hey, here's what it looks like, but always follow it up with, but don't rely on me. So especially if it's in writing, put that, don't trust me, check with, if you really want to know, get a survey done. All right, dispute resolution. This section says that that we're agreeing if there is a dispute, we shall, trying to highlight it, there we go. We shall first go to mediation before going to court, okay? So if there is a dispute, we have to go through mediation first. Attorney's fees says in the event you end up in court, the prevailing party is entitled to reasonable attorney's fees. So that's what this section is going through and explaining. All right. Next is buyer authorizations, which actually, let me go back to this real quick. We actually just settled a lawsuit that we had going on with the company where our agent wrote an offer. It was a limited agency scenario, but he did a limited agency consent form, but he never got the buyer broker signed. It was a stupid lawsuit, in my opinion. We should not have even, it was dumb. The guy, it was a multiple offer scenario. The guy didn't get his offer accepted. And so he was suing us saying that we sabotaged him, basically, is what they were saying. Well, it ended up costing us some money and costing the agent some money because he didn't get this signed. And so we couldn't turn around and say, you now get to pay our attorney's fees. So anyway, it cost us a little extra money than what it should have.
So the agent didn't ever have a buyer broker.
Nope, he missed getting a buyer broker.
And what is the reason for such a thing?
He didn't have a reason. In fact, so the guy sued us, but he also filed a complaint with the Division of Real Estate. And so the division, now our agent currently is filing a response for why he didn't have a buyer broker. And he basically just said, I messed up. I should have it and I didn't. So
Yeah, because unless it's family or something like that, but even.
then you still should get it. Yep. All right, buyer authorizations. Section 9 here is the buyer is authorizing us to disclose after closing to each MLS in which the company participates the terms of the sales price. Why would we need that?
So they won't sue you for disclosing.
Well,
Yeah.
why could they sue us?
Because of privacy laws.
You're on the right track, but it's not privacy laws. Anybody remember from school?
Something about.
No, it's not.
Because it's not public record.
Yeah, why? You're right, because we're a non-disclosure state.
Okay.
There are only 12 states that are still non-disclosure, and we're one of the 12. So without permission, we couldn't put on the MLS what somebody sold their house for. So we get it signed here so that that's how we get around the law of not disclosing the purchase price. All right. The other thing that they're giving us permission to is to communicate with them for the purposes of soliciting real estate. That's to get around do not call lists.
So if ever the crazy, that client says, well, I don't agree with that. I don't want people to know.
So if somebody said that, then you would have to say that we can't put your home on the MLS. Because our agreement with the MLS is that we will put the sold
Yes.
prices out there. Yep. And in fact, there used to be a form that you could fill out that basically said the seller doesn't want it disclosed. And I was trying to find that recently, and so I called up the MLS and was like, I know this form used to be on there, and they said, yeah. Part of the clear cooperation rules that came about recently, and I don't remember how long ago clear cooperation came out, a couple of years ago, 2 or 3, but that, yeah, you basically, if you're gonna be on the MLS, you have to put the final sales price.
Okay.
The other thing this says is that we could put the money into an interest-bearing trust account and then donate the money to the Utah Housing or Utah Association of Realtors Housing Opportunity Fund. We actually are not currently doing that. We looked into it, but it was the red tape you had to go through was such a pain that we just decided not to do it. So,
So do we need a new form? An
Nope.
actual form?
no, we have permission to do it. It's just we're not going to do it. So. All right, section 10 is there are or are not additional terms. So you're either going to check that there are or are not. Most of the time you're going to be doing there are not to begin with. Later on, you may add addendums to it. And an example of when you would add an addendum to it would be, let's say that we had done it at 3% and we couldn't negotiate up and it ends up being 2.5%. You should do an addendum saying the brokerage commission fee is 2.5 plus whatever the percentage or amount, 295, 495, whatever you did.
That way, with that addendums, we'll avoid the client having to pay the difference.
Correct. The addendum stops them from having to do that.
Right.
All right, section 11, equal housing opportunity just says that we'll comply with all the federal, state, and local fair housing laws. Electronic transmissions and counterparts. Again, this is how I'm explaining it to a client. Electronic transmissions and counterparts gives us permission to email these documents back and forth, to do signatures that way. And then the due on sale clause. Basically, and what you guys need to know on this as agents versus how I explain it to them. What you need to know is if the buyer is purchasing a home and they are doing either a lease option or a seller finance transaction, they need to be aware that it's possible that the due on sale clause gets enacted. Like I've been curious to see, and it hasn't happened really yet much, at least, is because people have 3% interest rates and versus 7%, that some people might start offering, hey, seller finance, we'll let you seller finance whatever the first mortgage is, go get a second mortgage for the difference of whatever the equity is that the seller has. That way they have this lower interest rate. But if you do something like that, make sure that the client is aware that if the lender for that first mortgage were to find out, they could call that note due and payable, in which case now that the buyer has to pay off the whole thing in order to stop foreclosure. So anyway, that's the whole idea of this due on sale clause is if the buyer's doing a lease option agreement or a seller finance transaction, they need to be aware that it's possible that could happen. And I, especially with rates where they are, if a bank found out somebody was doing that, there's a pretty good chance they would say, okay, you need to pay off the mortgage right now. So, because they don't want 3% rate if they could get 7%. So, all right, next is that this is the entire agreement, including, so what this is saying is including the buyer due diligence checklist, the wire fraud alert disclosure, and any other addenda contained is what constitutes the entire agreement. So part of what this is saying, just to make sure you guys understand, is just because you have the buyer broker sign, if you don't also have the due diligence checklist and the wire fraud alert disclosure sign, you are missing a complete, this is not an entire agreement. Yep. All right, so then the buyer's gonna sign it, you're gonna sign it on behalf of the brokerage, and before we flip to the next page, I always like to stop and point out, oops, Do you have a real estate need, a property to sell or purchase outside of our market area or the state of Utah? Always stop and just ask your clients that when you get to this section. Oh, by the way, if you have a property you're wanting to buy either outside of Utah or in this case, sell to come to Utah, I can help you get an agent for that will take really good care of you. That way you can get paid a referral.
Okay, so that's because of the referral, right?
Yep. All right, next, buyer due diligence checklist. We already talked a little bit about it. Again, this is the form that says we're trained in the marketing of real estate. That neither the company nor its agents are trained to provide any of the professional advice regarding the physical condition of the property, blah, blah, blah. And then you'll notice in all caps here, it says that the buyer is advised not to rely on the company or any of the agents for a determination regarding the physical or legal condition of the property. So again, we're just having them sign this and we're explaining to them any of these that are in bold are areas that you could talk to a professional, and I am not that professional. And then have them sign this. So I always say to think of this as this is your get out of jail free card.
Well,
Yeah, the buyer due diligence checklist, because if they come back on you or us to try to say, you told me that the property, that the zoning for this property was gonna be okay or whatever. We're gonna immediately pull this out in court to say. We disclosed to you right here that. We're trained and not to rely on us. So that's why, again, if they ask me questions, I always say. I'm advising you not to rely on what I'm about to tell you if you're gonna tell them anything. If they have questions on any of this stuff, get a test done by a professional. We're not it.
so at one point, I'm just curious, because the agent that didn't even have a buyer broker agreement probably didn't have this either.
I can't remember if he did have the due diligence. I wanna say he did, but
But at what point did you give this
I do it at the same time.
at the same time?
And because remember, let me go back to the buyer broker. It says right here, this exclusive buyer broker agreement, including the buyer due diligence checklist.
Which is that
And the
one.
wire fraud alert and any other additional data that contains the entire agreement.
So really, it's not just that, they should be signing all of that.
They should be signing all those, at minimum, those 3 documents. All right, next form is the Century 21 receipt acknowledgement. So this one is just an extra layer of protection for you. And here's part of why I say that, and this is just my own opinion. But when you pull this form out, the buyer due diligence, and you place that in front of somebody and you're like, okay, here's all the areas. They could very easily come back and be like, well, I didn't read it, I just signed it. Which, by the way, in the state of Utah, when you sign something, you signing it is acknowledging that you have read it and you understand it. So the fact that you have signed it, the law would say, well, you shouldn't have signed it if you didn't understand it or read it. But because I know that people do that, we have this extra layer of protection for you. So this is a receipt and acknowledgement of buyer due diligence. And it says that they've carefully reviewed the due diligence and they understand their right to the following tests and evaluations. And then we have them go and initial here for home inspection, home warranty, mold, electrical plumbing, all of this stuff. So the idea of this form is if, again, we ended up in court and somebody's like, well, I didn't know I could have had a home inspection. We're gonna pull out and say, well, first off, we told you here in section 10 of the buyer due diligence that you could do a physical condition inspection. We also had you initial next to this saying you acknowledge your right to have a home inspection. So like this just gives us extra protection. If you did have somebody try to sue you for one of these things, for us to be saying, we told you multiple times that not to rely on this, and then we have them sign this. Yep. All right, next is confirmation of earnest money receipt. So we're gonna get this signed once we receive the earnest money. So as soon as you get the earnest money, and you are the one that signs this one, the client doesn't sign this. But once you receive the earnest money, you're gonna come in and fill out the dates that you got it. and how you received the earnest money. Was it a personal check or whatever? And then you're gonna sign that you received the earnest money, or whoever received the earnest money will sign that. Okay? And then I recommend send a copy of this to the listing agent once you have it, to just show, hey, we've met our deadline of receiving the earnest money and depositing it within the time frame.
Send what to the listening?
The confirmation and receipt of earnest money. All right, limited agency consent. So we already talked about this, but the time you're gonna use this is when both agents are with the same brokerage. So if you're representing both sides, you're gonna use this, or if the other agent is with Everest, you'll use this as well. So you'll put in the name of the buyer, name of the seller, agent representing the buyer and seller, the name of the company and the property address. Then you'll come down here and either check one agent and put your name in here, or you'll check the two agents. I see your hand, Miranda, give me 1 sec. You'll check the box for two agents and then put in the names of the agent representing the seller and the buyer, and then buyer and seller both sign it, and then one of the agents. All right, go ahead.
Question for you on confirmation of earnest money receipt. I was told that if we use earnest that we can send a screenshot of the earnest confirmation. Does that suffice? Because I was still feeling like I should do double duty and still send the form.
So it's probably fine to send just the earnest, but I would agree with you. I think, what does it hurt to fill out the form that we received the earnest money and sign it? As long as you know.
Is- If that was a week ago, is it too late to send it now?
It's fine. Because
Okay,
on that confirmation of earnest money, you're just confirming that on, this date is when we got it. So it doesn't matter really when you sign it, you're just acknowledging we did.
Okay.
All right, so, any questions on limited agency? Are we good? All right. Next, wire fraud alert disclosure. So on this one, just remember that wire fraud is a legit thing that's going on, and banks and everybody are being extra careful on this. And I actually just went through this. I was just selling a property in Mississippi, and I ended up selling it for less than I actually owe on the property. And so I had to wire money to the title company there, or the attorney there, to sell that house. And when I went up to the bank, I gave them all the instructions, which I verified before I sent it. And then like the next day I got a call saying, we need to verify, actually it was the same day. We need to verify that you talk to the person, you know who you're sending this wire to, you're 100% sure that you've got all the correct information, because we're not going to send the wire without it. And I was like, yes, I promise I have. I can't believe how difficult it was for me to actually wire the money out on it, which I appreciate,
But it
because
better be, right?
what?
It better be.
Yeah, better be, but so like I say, the reason I wasn't too concerned that I was starting to question if I had the right information because of how they were like, are you sure? And I was like, yeah, I'm sure, I think. I think I'm sure. I'm not so sure anymore, but I started to question it, but the reason I finally was like, no, I know I got it right. Is typically when you're selling a property, somebody isn't going to think you're wiring money. So it's more so for sure. I guess my point is, we have this for both buyers and sellers, but make sure you really emphasize with the buyer of like, if the wire gets sent out and it's wrong. But so it kind of gave me some comfort knowing the banks are really being cautious too of, are you sure? Have you talked to the person? You're positive, you know it's the right person you're sending this to. Because once that wire's gone, it's gone. So which that's not totally true, but shortly after it's gone, it's gone. So meaning once the bank actually releases the funds. So all right, next. So you're gonna have them sign that, which I guess actually let me just point out to make sure. Just these are the things you want to point out to your client. Never trust wiring instructions that are sent via email, never send your personal information, never click on attachments, always independently confirm wiring instructions by personally talk to them. Here's how I tell the clients. call me and verify that you are calling the right number. And or if you don't know, so what I did when I started to question myself on that wire, I went on to Google and did a search for the name of the company that the agent had told me we were using. And then I called from that number to say, hey, my bank wants me to verify. And you did send me that, and these are the right instructions, correct? And, confirmed it. So always confirm the contact information and always take steps to secure. So anyway, they signed it. All right, next is the affiliate business arrangement disclosure. So this one, the purpose of this form is to satisfy RESPA. So because Inspiro and North Star Title are sister companies to Everest, we have to get this signed. So the key thing to remember on this is you're going to put in your client's name at the top, the property address and the date, and that you're giving them notice that we have a business relationship with Inspiro and North Star. And the key things on this, luckily agents aren't really having a problem with this. When we first started doing this form, we had a lot of agents that were like, I'm not having my client sign that, because they felt like it was pushing their clients to use North Star and Inspiro, which we would love, obviously, we want to have that. But just keep in mind, in bold, it says here, you're not required to use these listed providers. So they're not required to. And it also says there are frequently other settlement service providers available that they could shop around and check. So, but RESPA just says, because we have a business relationship with Inspiro and North Star, we have to disclose this to the client. Sometimes people will say, well, what if they're not using them? You still need to get it signed, just because you never know when Inspiro might have to step in and save a loan. Like maybe all of a sudden your lender falls apart and you go down and go, hey guys, I need you to do me a favor here and help me out. And not saying that they'll always be able to, but if they can, you've already got this signed and ready to roll. All right. Next is.
What is an easy way to explain this?
The easiest way I explain it to the clients is I just tell them these are sister companies and we would love for you to use them, but at the end of the day, you get to decide. And I would at least recommend that you talk to them as a backup. So if you have a lender that you're comfortable with, you've already talked to, great, but at least let's talk to them so we have a backup. See, for me, I always want to have, if I've never worked with the lender that the buyer has, I'm going to always have them talk to Inspiro as a backup. Because the nice thing is we have a little bit of pull with Inspiro and North Star that we won't have anywhere else. Like if there's a problem, we can step in and be like, hey, we got to get something done. But if you come to me and say, hey, we're having this problem with fly-by-night mortgage, I might be like, all right, well, I'll try to call them, but versus I could go to Christopher and say, all right, we got to make this right. We got to take care of things. So. All right, next then is the lead-based paint. So lead-based paint disclosure. Remember, well, I'm going to ask you guys, when do we have to use this? Properties built prior to when?
1978.
So if the property was built in 1978, do we need it? Yes?
Yes.
Zoom? What do you got?
No,
So I have a yes and a no.
Was prior, but still 1978, right?
So if it's 1978, you're okay. If it's 77 or older, you need it.
So
Now, here's the thing. Is it gonna hurt to have it? No. Like I've done a lot of bank foreclosures and they put this in every time. Doesn't it, if it could have been built yesterday and they're gonna use, so it doesn't hurt to have it, but it's required prior to 1978 if the property's built before 1978. And remember on this, the seller will have filled out section 1, so hopefully Jason went over that. Section 2 is the seller's agent acknowledgement. Section 3 is where the seller, or excuse me, the buyer is going to either say they're going to take a 10-day opportunity or waive. So you'll notice here under C, there's I or II. One or two here, you're either going to initial that they're taking a 10-day opportunity or they're waiving the opportunity to test for lead-based paint. The key thing to remember is if they initial up here, if this box is initial, we must also have the lead-based paint addendum. So if you initial, your client initial, sorry, if your client's initial here, you need the lead-based paint addendum. So the disclosure is required prior to 1978. Addendums only used if they initial this box. And then buyer sign it. Last form is how you get paid. This is the most important one of everything we're going through today, right? Getting you paid. All right, so on this, you're gonna put in the property address here, name of the buyer, name of the seller, what title company you're using. And then these boxes that are this kind of, I guess, tan color, I don't know, what is it? Is that tan? Yeah. Okay, any of these that are tan, if you click on them, I'm on a PDF. At which, by the way, you can only upload PDFs to Dotloop. And this form is actually an Excel form, so you have to fill it out in Excel and then print as a PDF to upload it. But while you're in the Excel, you can click on this and it would change it to commercial from you, so you have different options. So next you'll put in the purchase price of the property. Then you're gonna click on gross, net, or flat. The default should be gross, that it's being paid off the gross commission. What the percentage is that you're getting from the MLS, and or if you've done escrow instructions would go in here. If there's a commission to an outside referral company, then you would click on this and put yes, and then it'll open up another box over here that you will fill out to say who that referral fee is going to. If you're doing a commission advance, you would put yes here. The admin fee collected, which we actually need to get that changed because it's no longer an admin fee, it's a brokerage fee, but I think they're working on updating this form right now anyway. So the Century 21 brokerage fee collected, you're gonna put in the amount there. So if you collected $495, you put in $495. How much of the earnest money is held at Century 21 Everest, you're gonna put in there. Oh, go ahead. You don't have to raise your hand, just unmute and start talking.
I always feel like I'm interrupting you.
You're good.
The commission advance, can you explain that?
I don't ever want to, but yes.
I'm sorry.
No, it's good. So
I asked the hard questions. I'm sorry.
the only reason I say I don't want to is because I'm not a fan of this, but the commission advance, think of it as a payday loan. There are companies that will do payday loans with your real estate commissions, but you have to have the property under contract. So if you had a scenario where like, I need to get some money real quick and I got this deal, it's gonna close in a couple of weeks. You could go to one of these companies, but you pay an astronomical interest rate on it, but that's what that commission advance is. So if you had gone and gotten a commission advance from one of these companies and said, hey, give me my commission beforehand, they usually will only give you half of the commission up front like that. But that's what that is. So if you had done a commission advance, you would switch that to yes and then fill out who the company was, which we only have a couple of companies that we typically work with on that. So if you're gonna do it, get us involved because we need to make sure it's one of the approved companies.
So it says in here, commission advance, but when you said they charge you an interest, that sounds more like a commission loan than advance.
Yeah, it's a commission loan. It's
Yeah.
It's a you're getting the commission up front, but it's
a
like a payday loan. And I don't know what their interest rates are, but really high.
Wow. So it's advisable not to do that.
Yeah, that's why I usually kind of just gloss over it, is because I'm like, don't do it. Go borrow money from somebody else's. I mean, agents do it. I don't like, there are times, so I shouldn't say that, but there are times that it's got to happen. It's just you pay a lot of money. So maybe I should just start one. If you need one, come see me.
I charge less interest.
I don't know if I'll charge less, but I want, yeah. I need to find out what they charge. Maybe I'll create my own. All right. Earnest money held by Century 21 Everest. If we are holding the earnest money, you'll just put in there how much it was. And agent credits given at title. So if for some reason at closing you were like, oh, in order to get the deal done, I had to give up $300 of the commission, you would put that in there. So, and then this is good. What this is going to do is tell us how much your commission check should be from the title company. So just as an FYI, so if I don't know how many of you will look this detailed, but let's say that I had put $1,000 up here in this earnest money held by Everest, The check down here would have been $8,295. Because we transfer the earnest, the earnest money is deposited with us. Once it closes, we transfer the earnest money from the trust account to our operating account. And you get paid the commission. Part of your commission is that earnest money, if that makes sense. So just if you're ever looking at it, you're like, it feels like that's less than I should be getting. It's because of the amount that's up here for earnest money will get added to it. All right. Next, you're going to decide, is it a single agent or if you're on a team? So if you're on a team, you're going to click that, you'll click team, and then it'll open up another box over here. If you're just single agent, you'll leave it single agent, you'll type your name in there. It then deducts the $295 portion of the Everest fee of the brokerage fee comes out here. So if I had collected up here $495, it's going to deduct $295 of it, of that $495. And then, so an additional 200 would show under here. Make sense? So that's why this goes from 9,295 to 9,000 right here, is it's deducting it out. So if you didn't collect it, if you had put 0 up here, this would have shown 9,000 here, and this would have shown as what, $8,705, right?
Sure.
Did I do my math right? You get what I'm saying. All right. Next is the split that you're on with Everest. So whatever your split is, so if you're on a 70-30 where you're getting 70%, you put 30% here. So whatever percentage you put in here is how much is going to Everest. It then calculates the 6% franchise fee, deducts that from it. And then if you had not collected the $295 up there, it would then deduct it right here. So instead of showing 0 here, it would say $295 if you didn't collect it. And then if you want to donate to the foundation, the recommended amount is $21, but you can do whatever you want, including 0 if you want. But if you want to donate to the foundation, you can put money in there. If you're using a transaction coordinator, their fee goes here. But if you're using a transaction coordinator, don't fill this form out. That's what you're paying them to do. So
This one, you mean?
yeah, if you're using a transaction coordinator, you don't have to fill this form out. That's one of the advantages. So if you're ever filling this out and you get to this and you type in their name there, you just did their job for them. So you can, I'm sure they appreciate it. But all right. And then it's going to come with, here's what your expected commission amount will be. And is it direct deposit? If it is, click the drop down here, change it to yes, and it'll be direct deposited to you. If not, you'll get a check. And I think typically the next day. All right, questions? All righty. Okay, so I'm going to make let's see. Does the TC fill out? Oh, yes. Correct. Yep. I don't know if you typed that before I answered it. Probably. So, okay, so we're done for today, but I'm going to do a really hard sales pitch to specifically Jason, no, to everybody. But if you, it looks like you're at the office, Jason. Are you at it? Are you in Layton? Oh, all right. If you can be here, which I already know Jordan can, so I will make an exception if you can't. But if you can be here on Thursday this week, come in person. It's more fun because we're playing a game, and the game is more fun. I almost said funner. The game is more fun if the more people we have in person. But if you can't, I get it. But if you can, then be here. And if you can't, then I guess Jason and Jordan, because are you going to come, Jason, or no? Oh, all right. So I guess you and Jordan will be a team because Jordan will be in St. George too. So you guys will compete against us, and good luck winning when you're not here.
Good job.
All right. Okay. Thanks for being here, guys. If on Zoom, if you did not put it in the chat box, make sure you put your name in the chat box. And I'll see you guys on Thursday for a fun game.
Thank you.
Thank you.
You're welcome.
When I put my license number.
Yeah. Well, I don't know. You haven't been done. Well, you already probably got this credit. Haven't you, for the $12 region? It's up to you. You
I-
put your number.
The 12 hour agreement, no,